distinction students, welcome to our civic education online class. We're still discussing the introduction to the major human rights instrument, introduction to the major international human rights instruments. So the first video discussed the charter-based human rights instrument, as well as the background to the charter-based human rights instrument, the UDHR, and it also gave a brief description on the International Bill of Rights. Okay, so we continue from where the first part of the lesson ended. So this video will discuss the optional protocols to the International Covenant on Civil and Political Rights. So we need to understand, first of all, what we mean by optional. So when something is optional, it is not forced. It is something somebody does voluntarily. Okay, so for instance, in schools, we have subjects that are optional and we have those that are compulsory. So the optional subjects, one chooses to take them or not. Then for the compulsory subjects, they're taken by everybody else in school, whether one likes it or not. Okay. Then protocol, on the other hand, is a manner in which something is conducted. Okay. Which is an accepted way of doing something. All right. So under the international law, an optional protocol is a provision that is attached to an international instrument, which is meant to offer more protection of the rights in the treaty. Okay. The ICCPR has two optional protocols that are related to it. We have the first optional protocol and the second optional protocol. So under the first optional protocol, there's a provision of an individual to complain on human rights violations that are contained in the ICCPR to the United Nations Human Rights Committee. So when a country accepts its this optional protocol, it means that it has agreed to allow individuals to complain to the Human Rights Committee, provided they exhaust all channels of complaints. Usually, it's through the court systems in their own country, unless the means of seeking redress in one's own country is unnecessarily long. So the committee will not look at complaints that do not bear the name of the complainant or that are being examined by another international procedure. So the first optional protocol was adopted at the same time as the ICCPR and the ICECSR in 1966 and came into force in 1976. So Zambia is the state party to the first optional protocol. Then when we come to the second optional protocol, now this is where the International Covenant on Civil and Political Rights aims at abolishing the death penalty, okay, which was adopted by the General Assembly by its resolution 44/128 of 15 December 1989. It was adopted in 1989 and came into force in 1990. Now, this protocol was aimed at the abolition of the death penalty in countries that ratify it. The protocol works in the belief that Article 6 of the ICCPR, which protects the right to life, translates into abolition of the death penalty. Now, under Article 1, no one within the jurisdiction of a state party to the protocol may be executed. Okay, so no exceptions are allowed for the abolition of the death penalty except in time of war, after a conviction for a most serious crime of a military nature that is committed during wartime. Now, Zambia is not a state party to the second optional protocol, and that is why it still has the death penalty as a criminal punishment. Now, the supervisory mechanisms under these protocols, the Human Rights Committee monitors the implementation of the International Covenant on the Civil and Political Rights. Then we also have the interstate complaints procedure, the individual complaints procedure under the first optional protocol, Then we also have the state party reporting. Then, having talked about the optional protocols to the International Covenant on Civil and Political Rights, let's take a look at the specialized international human rights treaties. So we know that apart from the Universal Declaration of Human Rights, the UDHR, we have the International Covenant on Civil and Political Rights, the ICCPR, with its first optional protocol and its second optional protocol, the International Covenant on Economic, Social, and Cultural Rights, which together make up what is known as the International Bill of Rights. Now, there are other specialized human rights treaties, and these are referred to as specialized because they focus on a particular human rights issue or a particular group of people. Now, among these specialized human rights instruments, we have the International Convention on the Elimination of All Forms of Racial Discrimination. We also have the Convention on the Elimination of All Forms of Discrimination against Women. We have the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. We have also the International Convention on the Protection of the Rights of All Migrant Workers and members of their families. So to begin with, let's take a look at the International Convention on the Elimination of All Forms of Racial Discrimination. Now, this one, the convention was actually adopted in 1965 by the United Nations General Assembly. Then it came into force in 1969. It was drafted to draw attention to racial discrimination that was still rampant in the world. America was still a very much segregated society even after its 1964 Civil and Political Rights Act. Then when we come to South Africa, there was apartheid, okay, which was a principle that was used to define or rather separate, or that was a principle defined as separate development, but was in effect segregation based on what? On race. Now, the rest of Africa was under colonial rule, and the Africans were segregated against in all spheres of life in their countries. Then the principal definition of this convention is any distinction, exclusion, restriction, or performance based on race, color, descent, or national or ethnic origin, which has a purpose of effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life. So, a part of the convention allows for specific distinction between citizens of a country and non-citizens. That is why we find that citizens of all countries enjoy certain rights that foreigners cannot. For instance, the right to vote is not extended to non-citizens of a country. Then, another part of this convention also allows the state to take special measures for the purpose of facilitating the progress of certain racial or economic groups or individuals that are requiring such protection, so as there is equal enjoyment of the rights and freedoms that are guaranteed in the convention. For instance, we have the affirmative action in South Africa. This action is meant to bridge the gap between the whites and the blacks in economic benefits of the country. And adding on to that, we have the lower cut-off points of girls to qualify to higher grade in the Zambian school system. Now, this one is meant to bridge the gap in educational opportunities between boys and girls, okay? Now, states should be careful not to bring about separate rights for different groups or individuals. Once what it wanted to achieve has been achieved, it should do what? It should discontinue such actions. So, having talked about that, Zambia is also recognized as a party, okay, because it became a party of all this in 1972. Now, the summary of the provisions that this convention has is the condemnation of racial discrimination, segregation, and apartheid. Then we also have prohibiting the practice of racial discrimination by individuals or organizations. We also have the condemnation of all propaganda and all organizations based on ideas or theories of superiority of one race or group of persons, of one color or ethnic group, and to declare such an offense punishable by what? By law. Then we also have prohibit and eliminate racial discrimination and to promote equal treatment in the enjoyment of civil and political rights, as well as economic, social, and cultural rights. Aside from that, we have ensuring to everyone within the jurisdiction, effective protection and remedies. We also have to undertake immediate and effective measures in education, culture, and information with a view to combating prejudices which lead to racial discrimination. Then what are some of the supervisory mechanisms? We have the Committee on the Elimination of Racial Discrimination, which monitors this treaty. We also have interstate complaints procedure. We have the individual's petitions procedure. We also have the state party reports. Then we come to the second convention, which is the Convention on the Elimination of All Forms of Discrimination Against Women. Okay? Although the principle of non-discrimination on the grounds of sex is included in the International Bill of Rights, women and girls still suffer some of the worst discrimination all over the world, especially in socio-economic field. Women are generally denied a fair playing field in the society. Okay, so the United Nations therefore recognize the need for human rights instrument that directly addresses women's issues, protects and promotes their socio-economic as well as their civil and political rights first. Now, in 1967, there was a declaration on the elimination of all forms of discrimination against women. When the declaration did not effectively address the problem of female discrimination in the world, the legally binding Convention on the Elimination of Forms of Discrimination Against Women was adopted in 1979. Okay? It is often described as the International Bill of Rights for what? For women. Now, the principal definition that we have under this convention is that any distinction could be the exclusion or the restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on the basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. Okay? Now, in short, a state's party is obliged to afford equal treatment to women and men. And in this regard, state parties undertake, among other things, such as embody the principle of equality of men and women in their domestic legislation, establish legal protection of the rights of women on an equal basis with men, eliminate all discrimination against women, modify or abolish existing legislation and practices which constitute discrimination against women, eliminate discrimination in the enjoyment of civil and political rights as well as economical, social and cultural rights, so that women are ensured equal rights with what? With men. Then we also have accord women equality with men before the law, including affording women a legal capacity identical to that of men. Then aside from that, we have the elimination of the discrimination against women in all matters relating to marriage and what? And property. Okay, so this convention has an optional protocol which allows the United Nations Committee on the elimination of discrimination against women to receive and hear cases of violations of women's rights. The optional protocol requires that the complaint, which is called a communication in international law, all right, be in writing, bearing the name or names of the complainant, and has exhausted all avenues of redress in one's country, unless such avenues have been unnecessarily examined, and that the particular complainant complaint is not being examined by another committee. Okay, then the committee will refuse to hear cases that are not in line with the provisions of the convention. So what are some of the supervisory mechanisms? This one talks about the Committee on the Elimination of Discrimination Against Women monitors this treaty. Okay, we also have the individual complaints procedure under its optional protocol. Then we have the inquiry procedure as well as state party reports. Then the third convention is the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. All right. Now, this one, despite the fact that torture, cruelty, inhuman, or degrading treatment or punishment were already categorically forbidden in both the Universal Declaration of Human Rights and regional instrument, there was a general view that a special instrument to forbid absolutely, without reservations, torture and inhuman or degrading treatment or punishment was needed, because the earlier instruments had not completely stopped human rights violations. This convention, popularly known as CAT, came into being on 10th December 1984. Zambia signed it in 1998. Now, what is the principal definition? It is defined as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or her a third person information or confession, punishing him for an act he or she, a third person, has committed or is suspected of having committed, or intimidating or coercing him or her, a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent of acquiescence of a public official or other person acting in an official capacity. Now, in legal terms, what do we mean? As we have defined, torture may only be carried out by the state and in various institutions. Cruelty exercised by non-state individuals or institutions against other human beings is legally not regarded as torture, but physical abuse exercised. Now, the summary of these provisions, we have prohibiting torture, not to refoul. Now, this means to send back a person to a country where he or she is likely to undergo torture. Okay, this is especially in relation to refugees running away from persecution. Then we also have punishing torturers, educating citizens on the evil of torture, rehabilitating victims of torture through counseling, controlling the system of interrogation and detention, reporting to the committee. Then the mechanisms that we have Committee Against Torture supervising this treaty, interstate complaints procedure, individual complaints procedure, inquiry procedure, as well as state party reports. Then under this one, we have negative and positive rights. When we talk about negative rights, we are describing those rights that require the government not to interfere with an individual from enjoying rights and freedoms. For instance, the government should not stop someone from the right to assemble or the right to join a political party of one's choice. Negative rights are the right not to be discriminated against, or the right not to be subjected to arbitrary arrest. Then when we talk about the positive rights, these are rights that describe a right which requires the government to take action in order to fulfill and to make the individual realize the rights. For instance, the right to education and the right to what? To health. Okay? Then the fourth one, which is the last convention, we have the International Convention on the Protection of the Rights of All Migrant Workers, okay, and members of their families, which was adopted in 1990, okay. So, in December 1990, the General Assembly adopted the International Convention on the Protection of the Rights of All Migrant Workers and members of their what? Families. In short, states which ratify or assent to the convention undertake to ensure that migrant workers whose rights have been violated may seek judicial remedy. All right? So, migration from one's country of origin to go and work in another country is not a new concept. Women and men have been leaving their homelands in search of work elsewhere ever since payment in return, all right, for labor was introduced. Now the difference today is that there are far more migrant workers than in any period of human history. Millions of people now earning their living or looking for paid employment came as strangers to the states where they live, right? There is no continent, no region of the world which does not have its groups of migrant workers. Okay, so now poverty and the inability to earn enough or produce enough to support oneself or a family are major reasons for the movement of work seekers from one country to the next, right? So now other reasons as to why people go abroad in search of work are wars, civil conflicts, insecurity, persecution due to discrimination on the grounds of race, ethnic origin, color, religion, language or political opinion. Now, the main reason for coming up with the International Convention on the Protection of the Rights of Migrant Workers and members of their families is that persons who qualify as migrant workers under its provisions are entitled to enjoy their human rights regardless of their legal status. The convention borrows from relevant international labor standards, and these are the slavery conventions, the UNESCO's Convention Against Discrimination in Education, the International Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Code of Conduct for Law Enforcement Officials, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment, Punishment, the Convention on the Rights of the Child, the Declaration of the Fourth United Nations Congress on the Prevention of Crime and the Treatment of Offenders. So, the convention defines those rights which apply to certain categories of migrant workers and their families, and these include the frontier workers who live in a neighboring country to which they return daily or at least once a week, the seasonal workers who get work in foreign countries during specific seasons such as harvesting or planting season, or the seafarers employed on water vessels registered in a country other than their own. We also have workers on offshore installations which are under the authority of a country other than their own. We have the itinerant workers who move from place to place in search of work. We also have the migrants employed for a specific project. For instance, we have construction of roads or dams or industrial plants. And the last one is the self-employed workers. Now, what is the principal definition of this convention? The convention is applied to all migrant workers and members of their families without distinction of any kind, such as sex, race, color, language, religion, or conviction, political or other opinion, national, ethnic, or social origin, nationality, age, economic position, property, marital status, birth, or other status. This convention actually applies during the entire migration process of migrant workers and members of their families, which comprises preparation for migration, departure, transit, and entire period of stay and payments in the state of employment, as well as return to state of origin or state of habitual residence. Okay. So aside from that, this convention prohibits discrimination in the enjoyment of the rights contained in it. All right. So it provides for the rights of all migrant workers, irrespective of their migration status, and additional rights which are provided for properly documented migrant workers and their families. So most of the provisions require the host country to take measures to protect the rights of the migrant worker and his own family. Okay. However, some provisions require the country or origin to take measures to protect the migrant worker and his or her family. Now, the summary of these provisions are: there is non-discrimination of migrant workers and their families without distinction of any kind, such as sex, race, color, language, religion, or conviction, political or other opinion, national, ethnic, or social origin, nationality, age, economic position, property, marital status, birth, or other status. Then we have the migrant workers and members of their families shall be free to leave any state, including their state of origin. Then aside from that, migrant workers and members of their families shall have the right at any time to enter and remain in their state of origin. Then the right to life of migrant workers and members of their families shall be protected by law. No migrant worker or member of his or her family shall be subjected to torture or cruelty, inhuman or degrading treatment or punishment. No migrant worker or member of his or her family shall be held in slavery or servitude. No migrant worker or member of his or her family shall be required to perform forced or compulsory labor. Migrant workers and members of their families shall have the right to freedom of thought, conscience, and religion. Migrant workers and members of their families shall have the right to hold opinions without interference. No migrant worker or member of his or her family shall be subjected to arbitrary or unlawful interference with his or her privacy. Now, we come to the supervisory mechanisms. This one also has the Committee on Migrant Workers. It has individual complaints mechanism. It has interstate complaints mechanism, as well as state party reports. So this is where our second part, our last part of the lesson ends. So please go through the video as many times as possible to better understand. Do not forget to subscribe to this YouTube channel so that you are so that you are notified once videos are posted. Okay, so make sure that you are able to define the charter-based human rights instrument, describe the background of the charter, and discuss the mechanisms that are used by the United Nations in monitoring and supervising implementation of the charter-based human rights instrument, and the provision of the summary of the provisions that are contained in the UDH and the treaty-based international human rights instrument. So all these are things that you should be able to talk about after learning this lesson. Okay, this is your tutor, Miss Cynthia Mrinda. Please continue studying.